So, dear friends, now we are going to take a live case study. This is, you have to go through the previous one and let us understand how the judgment, how to pick up points from each paragraph. As we have been discussing, we find out all the points, because here you are going to test the violations, procedural violations, legal violations, natural justice violations, any fundamental rights affected. Those things have to be captured. Arbitrariness, natural justice, and locus standi, necessary parties, all are important. These all to be tested by you. But our idea is, after finding all those things, maybe 20 items are there, 15 items are there. You have to pick up 5 items, 4 items, and put them very nicely in the synopsis. This is the purpose of my lecture. So many points will come. And how to emphasize those points as valid points to convince the judge. One is, the learned judge comes and prepared, just scans and comes. If he's convinced, he'll give stay and then notice over. Second thing is not convinced. You have to convince him sometimes how to go about it. And there may be large points, but you don't bore him in the initial stage. That is what we are going to learn as advocates on record. You see here, the above application has been preferred by IDBI Bank, represented by General Manager 65 and 11, Rule 11. This is the things, right? And then what is he seeking? A is a normal thing. We cannot understand what is that. B is the essence of it. Remove the person as liquidator is functioning. You please remove the liquidator is the relief sought. So the first question arises, who are you to seek somebody's? So locus standi is there. So there, yes, I'm a financial creditor. I have lent so much money and etc. You can say grievance. But the law, what does it say? You have to go to the provisions of the code. How liquidator can be removed? Is it there? That one you check up. Whether this person has got a right to seek removal. So the law says financial creditor in a liquidation is only a claimant. He has no right to seek removal of liquidator. Where is the judgment? Punjab National Bank versus Kiran Shah. Whether that judgment has reached finality is not been challenged before Supreme Court. Therefore, as on date, this is the law. So when the law is there, that is a precedent. It is binding on the tribunal. Small appellate tribunal's decision is final. So here is overruled that. Did he give reasons for overruling? Whether you have raised that issue? Understand, this is a petition filed by IDBI Bank. Whether the liquidator respondent raised that issue in written submissions. And what is the citation he has relied upon? It's a vital point. See, somebody's wife is being taken by somebody else. It is that fellow who should be bothered as a husband, not you. That is called locus standi. You understand? So that is a settled position of law. And secondly, remove the liquidator, you said. Can the liquidator be removed? There are laws. Whether resolution professional can be removed? Yes. The law says, you read section 27. So 27 says, the committee of creditors will have to pass a resolution for removal of a resolution professional. 66% should vote. Once that resolution with that 66% voting is there, he stands removed. That's all. Commercial wisdom of COC is not justiciable. That is a settled position of law. So you don't have any right, you have to go. But whether the same law applies to liquidator, then you have to go and see. Here they are challenging the appointment made by the NCLT. So what power NCLT has used, adjudicating authority, to appoint him? Whether that there is any infirmity in that power used, regulations applicable to that. That is the law. Now let us see what the judge said. So first para 2, the facts, matter of fact, the company went into liquid IBC. Then COC appears 90% resolved to retain the resolution professional. So it is the IDBI which got him appointed. You want to remove him. And 90% of people are happy. So actively involved. That means the liquidator is, that is resolution professional, is doing good job. Taking everybody into confidence. That itself they show. Then why do you want to remove him? Is the next question. So fourth point, court appointed based on this. But here he is now saying there is a violation of regulation 7A. There are two things. What he says is regulation violation is important. Whether you are having certificate or not, you apply the certificate, the law says within 15 days it should be given. And either it should be rejected or given. If you don't give or reject, then it will become deemed provision, given. Here the appointment was approved by IBBI. The RTI file shows even after 8 months the matter is being pending. They knew it. They suppressed it. The liquidator pleaded. This is the regulation 12A5 is there. Bylaw, deemed provision is there. There is no need. No regulation is violated. You should have made IBB as a party. You could have brought them here. Nothing happened. Right. So suppressed. They are not argued. That also didn't take. Now, the applicant contends that respondent did not possess valid. Valid means what? Doesn't functions. And he should be removed. That's all. Suppress the material fact. Where you suppress it? When it is rejected, you have it statement and you don't say, that is suppression. Here rejection approval is there by the IBBI. Now he himself says he does not have. See 8th para. Now what is that recording says? This is actually, it was not at all there. This plant and machinery buildings and this paragraph is irrelevant. Nobody argued, nobody discussed. And liquidator submitted. This is actually is not like this. He has explained that Kiran Shah, Punjab National Bank says this. They are only claimants. Therefore, they don't have locus standi to call. And also, they are not surrendered the security interest. Therefore, they are not part of the stakeholders committee. They can't vote also. And this is what I said. He wrote it. The order differently wrote, as if to prove that liquidator is saying that nothing can happen to me or something like that. This is the law. Here he is working very well. And he has that point in time, he's established that company will go for 1,000 crores. When 100 crores, they are not able to get it in the CIR process. That's why it went for liquidation. So then we have said the liquidator is appointed. He can be removed only by serious allegation. That is section 276 or anything. But the learned judge, he immediately applied Section General Clauses Act 60. So it's a 34(4) is the relevant law, which gives power to appoint. Instead of that, there is no infirmity. He ignored that and he came to this Section 16. And power to appoint General Clauses Act. This IBC is a code, a complete code. You cannot come into General Clauses Act if that is the purpose. And Then General Clauses Act, he says that power to dismiss the liquidator since authority is vested with power. Power is appointed under 33, 34. So you have to apply that power. Understand? The power which gives appointment to a liquidator, that power is not, that says how to apply. There is infirmity only, it can be applied. Not otherwise. Why did he himself says? But he is using General Clauses Act. Infirmity. It's a vital infirmity. Dear friends, so far as we discussed, so many points we got it. Sloka stand is there. Necessary parties have not been brought. There is no violation of regulation 7A. And the fourth one is this one. Among this is the most important one when you are presenting, because all the other things you need to explain something else. Assuming that judge is and is not ready. This is not only IBC cases will go before Supreme Court. So many cases will be there. So remember that mind, that state of mind of Lordship, sir. So if he sees, sir, one bold statement, one wrong application of provisions. A liquidator is appointed under section 34(4). And if you are testing that violation, then the liquidator, it has to be established that there is violation in 34(4). There is no infirmity in that. But they have applied section 16, General Clauses Act. It is a wrong application of the law. Hence, it cannot be applied. That's all. The case is over. The case is over. This is the first point. Because this anybody will understand. Correct? No. Whereas section A, regulation 7A, you have to explain situation 1, situation 2, situation 3, deemed provision. I received only this. This matter of facts, question of law, mixed facts and question of law. The judges may not be able to appreciate it that fast. And then IBBA should be appointed as a the necessary party, not considered. It's a okay. It is not such a vital point to consider infirmity. Locus standi is a vital point that can be decided whether to use it or not. But how do you say locus standi is not a vital point? That again you have to say Kiran Shah, security interest not surrendered. It may take time. It may come in the question of law grounds that, but in synopsis is not required. This is a vital point. That is how you have to screen the position. That's very, very important, dear friends. When we went to Supreme Court, first question Lordship said, Abhay Oka Justice, he said, I just came, I couldn't read it. But then the section 34 applies. Using 34 he has appointed. You find out the infirmity in 34. Why are you using wrong law? He said, straight. The Lordship is brilliant judges. Supreme Court is extraordinary. Here also this gentleman is good only, brilliant only. The point is the extraneous considerations have come and he made good of the situation, inflicting injuries to others. Now, this is unnecessary points and all he brought in. Then 276, let us say, he applied 276. 5 conditions are there. Are there misconduct, fraud, professional incompetence, inability, conflict of interest? Nothing. He didn't say anything. So how can you apply that? Assuming that is applicable. But you have to show under these provisions, he has done these facts of the case are such, he has done this, so I'm removing him. That's not there. And full pages are this. Now here, complete misrepresentation. He says, liquidator said, once he is appointed, nobody can remove him. Is it so? It is not correct. It shocked me. Therefore, I am removing him. And see, a very important point. It has been seen that previous hearings, serious allegations have been made against the liquidator stakeholders. First of all, that was not a subject matter. Whether it is right or not, defense also not there. So it is a without jurisdiction it will become. The act becomes without jurisdiction. Understand, this is the next vital point. The other ones are serious allegations of corruption. I didn't say there is no serious allegation of corruption. But here, why you want to remove him? What is the infirmity? Even there he didn't say. So he says, I am shocked in the earlier valuation report, B's valuation report circulation is wrong. If so, what is the pleadings? That he did not say. He wanted some reason to remove. Shook the conscience of this court, this tribunal. Because he wants to, they built a case, it's an arbitrary, without jurisdiction. Material that is never placed in discussion was considered. And there are very multiple judgments, starting with Animic, this Mohammed Nu. It's a violation of principles of natural justice. Per incurem order, it is Bilkis Banu. All judgments are before us. But this is a vital point. Next is, you have to see that where the points can easily go into the mind of the judge. That comes, shocks his, okay, yes, the mistake is done. That is the first point stands. Valuation report sharing is no mistake. And unless you give the valuation report or the value of an asset, what is the terms and conditions, all nothing discussed. Now, to support these things, that is valid IFA is not there, first point. So it's a violation of regulation. Without discussing it, then he depend on. At this point, there is a restraint order passed by Madras High Court is there. He didn't consider it. He didn't even discuss that. And this point, what they say is they appealed before NCLT. They said if you are saying there is a violation of regulation, you go to the same court which appointed. Correctly, they said. You can read that. And so if so far as that you convince the court, then he'll take a relook. Nothing wrong. And here is this he wrote. IPPI have issued show cause notice. Respondent stated that respondent accept the assignment authority. We never accepted anything. And the same is also the order passed by IPPI. But he did not write that there is a stay order. At the time of reserving the order, he said, you see, and all these cases are no, NCLAT never said that you remove. He does not have AFA, 12A5, nothing was discussed. And they have decided to remove me. Now you see, what he said is, he has failed to exercise due care and diligence in performance of powers and functions while discharging his functions liquidator in respect of corporate data. How is it concerned about due diligence? And he has used 33, 34, section 16, 276. And you see, he picked up from the IPPI list one person. This person was working, assisting the promoters. And he is got only 2 months before appointment, he passed this exam. Whether it is possible, out of so many list of highly experienced professionals, is it possible to appoint him? And this will fall flat under the RR Parekh versus these things. So this was removed. And 7 days, actually, the judgment, this judgment alone, on the last day of his retirement, he pronounced. But it was not uploaded for 6 days. And this is how the judge passed the order. And so let us take the next stage, how things were agitated before appellate court NCLAT. But mind you, friends, Honorable Supreme Court, you will get justice. But the way you present your case, as an advocate on record, you should learn. That's what I'm trying to explain, the live case studies. Thank you.